start. This civil appeal arises out of the final judgment and order of Gujarat High Court dated 23/7/2015 stop. The High Court partly allowed the appeal of the respondent, Union of India, and quashed order of the arbitrators and set aside the amount awarded by them in respect of claim number 12 stop. The arbitrators, under claim number 12 awarded interest pendency light at 12% on the award of rupees 30 lakhs excluding security deposits stop. Further, the High Court dismissed the review application filed by the appellant stop. The appellant and the respondent, Union of India, entered into a contract for quarrying stop, staking and loading stone ballast, broken stone aggregate, rubble, etc. from the Western Railway quarry stop. Para. Thereafter, disputes arose between the parties, due to which the appellant called upon the General Manager, Western Railway, to appoint arbitrators in order to settle the dispute stop. The arbitration proceedings commenced on 26/9/1988 and the award was passed stop. The arbitral tribunal, comprising of chief engineer and director, finance, awarded an amount as against the claim raised by the appellant stop. An award for the claim raised by the appellant was made stop. The present dispute relates to the amount awarded under claim number 12, that is interest stop. The arbitrators awarded the appellant interest pendency light at 12% on the award for damages excluding security deposits stop. Para. The appellant thereafter filed a civil miscellaneous application number 22 of 2001 along with the award in the civil court stop. The award was made a rule of the court by an order under section 17 of the Arbitration Act of 1940 by the civil court stop. The respondent challenged the order of the civil court in appeal stop. The High Court partly allowed the appeal and set aside the order of arbitrators claim number 12, under which the arbitrators had awarded a sum as interest pendency light stop. The appellant, aggrieved by the High Court's judgment and order dated 23/7/2015, filed a review application before the High Court stop. Para. The High Court dismissed the review application, void judgment and order stop. The present SLPS are filed against the High Court judgments and orders passed by the High Court stop. The question that arises for determination before this court is whether clause 16 (3), reproduced hereafter, of the general contract clauses restricted the power of the arbitrator to award interest pendency light ? In the present case, the arbitral tribunal, giving effect to the purport of clause 16 (3), did not award any interest on security deposits stop. Para. The clause in terms states that no interest will be payable on honest money, security deposits or on any amounts payable to the contractor under the contract stop. The arbitrators in their award have relied on clause 16 (3) of the contract to deny interest on the security deposit stop. The arbitrators held that what was intended under clause 16 (3) barred the grant of interest on earnest money, security deposit and amounts payable to the appellant, it does not in any way bar grant of interest pendency light stop. On behalf of the Union of India, it is contended that the arbitrators by reason of clause 16 within bracket 3 could not have awarded interest pendency light stop para. The contention is incorrect stop. In terms, the clause only bars interest upon honest money and security deposits or amounts payable to the contractor under the contract stop. The above mentioned amounts are amounts which in a sense belong to the contractor stop. They are amounts voluntarily deposited with the other contracting party in order to be refunded or forfeited depending on performance of the contract stop. As such, they are not amounts of which the contractor is deprived the use of against his wishes, so as to attract interest stop.